Good evening, everyone. I hope you can hear me and see me at this point. My name is Natalie Klein, and I'm the president of the International Law Association's Australian branch, and also a professor at University of New South Wales. And I'm delighted to be able to welcome you here this evening. I think we've still got some people joining us, but we'll make a prompt start. I'm very pleased to be able to welcome you to this seminar on COVID-19 and private international law, which is hosted jointly by the Australian branch of the International Law Association and also the University of New South Wales Faculty of Law. In welcoming you here this evening, I would like to acknowledge the traditional custodians of this land. And in my instance, it is the Bidjigal people, and I pay my respects to elders past and present, and extend that respect to other Indigenous people who are joining us here this evening. Now, for our discussion tonight, I'm very happy to have with us two eminent scholars in the field of private international law, who are both from the University of Sydney and also both affiliated with the Centre for Asian and Pacific Law of Sydney Law School. So speaking first this evening is Associate Professor Jeanne Huang, who'll be talking about collecting evidence abroad by video link under the Hague Evidence Convention and under domestic laws. And she will be followed by Professor Vivienne Bath, who will be speaking on private international law, mandatory rules and frustration of contract and force majeure, with particular application to China and Chinese contracts. Now I'm going to be switching my video and microphone off, and I will leave it for our two speakers. For those of you joining us, we have muted all of your videos and microphones as well, just to enhance the bandwidth for everybody. But please do feel free to put some questions in the chat, which you should be able to find the chat function on the bottom of your screen, which will bring something up on the side. And I will have a look at the questions, and then once our speakers have finished, we'll come back and pick up some of the questions from the chat that you've posted and be able to respond to those points. So without further delay, I'm very happy to hand over to Jeanne to start our presentations. Thank you.
Okay, so can everybody hear me? Okay, wonderful. Today I'm going to talk about the taking testimonial evidence abroad by audio or video link. So there are actually a lot of private international law issues in terms of taking evidence abroad. Due to the COVID-19, I think the most urgent issue actually is testimonial evidence. Why? Because of the travel ban. So evidence, natural person, they can't travel to Australia. So how to deal with those issues? I'm going to talk about the totally three issues. And the first issue actually is setting up a context of our discussion. So the first issue is which mode you are going to use for taking of evidence. Direct or indirect? That's the question. So what's the difference between the direct and indirect taking of evidence? They are hugely different. So the direct taking of evidence, so here, we suppose it's an Australia or New South Wales proceeding. So this is the so-called requesting state. On the other side is the requested state. It can be any foreign countries. So the direct taking of evidence essentially is a New South Wales proceeding administered by New South Wales judge. And the indirect taking of evidence is taking of evidence while the foreign authorities. The foreign authority can be judicial personnel in France, or it can be a judge, for example, in China. So the indirect taking of evidence essentially is a foreign proceeding. Direct and indirect taking of evidence it directly impacts on which law should be applied to issues, procedural issues such as taking oaths, perjuries, privileges, etc. Another very important difference in terms of how you decide direct or indirect taking is the possibility to cross-examine the witness. Later, I'm going to talk about Hague Evidence Convention. Actually, Hague Evidence Convention provides the possibility for cross-examination of the witness, but the issue is, if it is an indirect taking of evidence, the cross-examination possibly will be in the context as suppose you are the requesting court in New South Wales. You provide a list of the questions. So the impact of cross-examination is actually degraded. And the second issue regarding direct or indirect taking of evidence is the following blocking statutes. Most of the civil law countries consider taking evidence, even by audio or video link in their country, if the witness is their national and the witness located in their country, it is a way to violate their sovereignty. A typical example is the Swiss Penal Code. Another example is the French Penal Code. But if you look at our law, for example, in these two cases, our court considered the legislation authorizing the taking of evidence by video link, overriding any obligation that Australia might have had to respect another nation's sovereignty for reason of international comity or violation of sovereignty. So this is not unique for Australia. So actually it's quite a general view shared by other common law countries. So in most of the common law countries, we consider taking of evidence has nothing to do with the judicial authority or with the sovereignty in the requested state. But in civil law countries, generally they consider this is the violation of judicial sovereignty. But the violation of judicial sovereignty is a very abstract concept. What does it mean? So very important is you look into the law of the requested state. What's the consequence? Penal consequence, civil consequence, any consequence on the witness, and also possible on the person who taking the evidence. And now let's look at the Hague Evidence Convention. You may ask why Hague Evidence Convention is relevant or is so important that we should discuss. Because, as just now I mentioned, we consider we can take evidence abroad, even the requested country consider it is a violation of international comity or violation of sovereignty. Because the critical issue is, if one day you would like to enforce your judgment in the requested state, you have to observe their law. That's the very important reason if you contemplate in the future you are going to enforce your judgment abroad. And if the requested state require all the evidence taken abroad should follow Hague Evidence Convention, it will be a very good practice to follow Hague Evidence Convention. So I just want to quickly go through the legal issues, especially in terms of conflict of law issues in the Hague Evidence Convention. So regarding the chapter 1, Hague Convention focus on letters of request. So the argument is Hague Evidence Convention chapter 1 does not allow direct taking of evidence. Why? Because the taking of evidence should be conducted by letters of request. But this does not mean you can't cross-examine your witness. Why? Because in the letter of request, you can indicate that you would like to cross-examine your witness. But what's the difference between cross-examine your witness under the Hague Convention Chapter 1 and direct taking of evidence? Because here, cross-examination, essentially, it is not a New South Wales proceeding. It is still a proceeding of the requested state. And also, the requested state may refuse the cross-examining request. So here is the model letter of request. The requested state can reject cross-examination on what ground? So for example, it is impossible, impractical, or incompatible with their internal law. And regarding video audio taking of evidence, you also can indicate that in the letter of request. And the requested state will also consider whether to allow taking of evidence by video or audio link. Again, Hague Convention consider this is the special method of procedure subject to the internal law of the requested state, meaning that the requested state can reject that, of course, on the ground of incompatible with their internal law or impractical. Okay. Article 7 talk about the party present. And Article 8 talk about the judicial personnel present. Again, if we go back to cross-examination, and cross-examination may be conducted by party or by the judicial personnel. For example, a judge at the New South Wales Supreme Court. So Article 7 provides that parties can present, but a very important concept is, what does present mean? Does present means active participation? So again, this go back to Article 9, special method of procedure. If the councils would like to actively participate, actively present under Article 7, again, you need to indicate that in the letter of request. So how about Australian judge, a New South Wales judge would like to cross-examine the witness abroad? So this is the so-called judicial personnel present. Very important is a very important difference between Article 8 and Article 7 is Article 8 allow member states to do a declaration. So if a member state made a declaration that it has no objection for judicial personnel to present in the procedure to execute the letter of request. That's it. Okay, judicial personnel can present. But the situation is most of the countries, most of the member states do not make letter declaration. So it means that if an Australian judge would like to present at the procedure to execute the letter of request, again, this subject to the special method of procedure under Article 9, again, is subject to the internal law of the requested state. So how about the measures of compulsion? So for example, the witness refused to appear in, at the proceeding to execute the letter of request. Article 10 provides that the measures of compulsion should be subject to the law of requested state. So actually, here, as a common law lawyer, you may think this is very strange. Why? Because if you look at the New South Wales Act for taking evidence, audio or video taking evidence, actually it considered the proceeding is the New South Wales proceeding. But the issue is, under the convention, explicitly indicate the Chapter 1 letter of request is a proceeding of the requested state, not the requesting state. So how about the refuse to give evidence due to privilege or duty? So here, the applicable law, there are two options actually. The first option, possibility, the law to be applied is the law of the requested state. And the second possibility is the law of the requesting state. So here it means New South Wales law or Australian law. But very important, you need to specialize what privilege or duty that the witness can enjoy in the letter of request. Okay. So how about the perjury and contempt of the courts? The convention doesn't provide an answer. So presumably, this should subject to the law of the requested state. Why? Because it is a procedure of the requested state for executing letter of request. So chapter 2 is for councils and commissioners, which allow the direct taking of evidence. Okay. Now let's move to my third part, which is the internal law. So due to the COVID-19, evidence audio and audio video link in New South Wales, it has get an amendment. So which essentially broaden the possibility or the needs to taking evidence abroad. But regarding the internal law, as I mentioned at the very beginning of this presentation, if you envision one day your judgment need to enforce in a foreign country, especially the country where the evidence is taken, you need to look at its internal law. So here I use the Chinese law as an example. Why I use Chinese law? There are two reasons. The first reason is Chinese law is so different from us because it is a typical example of the civil law country, which consider taking evidence abroad when the witness, even it is a willing witness, if the witness is a Chinese national and located in China, the taking evidence abroad by video link is a violation of their sovereignty. And the second reason is just in recent months, there are very important Chinese legislation regarding taking evidence. So I think it is very valuable that we have a very brief discussion. So in Chinese law, the most relevant in civil procedures is the Article 276, it talks about the reciprocity. The reciprocity is a very interesting issue. Why? Because actually New South Wales, Australia, we allow Chinese court to take evidence in Australia. The witness is inside of Australia by video link. So the question is whether the reciprocity has been satisfied under Chinese law. Okay. The second issue is Article 277. So the first paragraph, it talks about international treaties, Hague Convention. And the second paragraph is the diplomatic channel. And the last paragraph explicitly indicates without the consent of the competent authority of the China, no evidence should be taken in China. But very different from French law and the Swiss law, Chinese law doesn't impose any liabilities or criminal offenses on the witness who voluntarily provide evidence to foreign court by video and audio link. So actually this link to the possibility that one day if your judgment need to get enforced in China, whether Chinese court will refuse enforcement or recognition solely based on taking evidence abroad. And I think actually this is arguable, you know, if there is no liability at all on the witness and also no liability on the lawyers, on the parties, why it is a violation of public policy or etc. So there is another very recent development in China. I think this is the first time very important the breakthrough in terms of taking evidence. So actually it's effective from the 1st of the March, the mainland Macau arrangement. So it allowed the taking of evidence abroad. Also, it actually allowed the court to arrange the witness travel to other other jurisdictions, and the witness should be immune from any criminal complaint or other detentions. So I just want to quickly conclude my talk. So on the last slides, I compare the difference between Chinese law and Australian law, especially New South Wales law, regarding oaths, perjury, and privileges. And the purpose is to demonstrate the conflicts between the two different laws. So for example, in New South Wales law regarding the oaths, so we can allow the New South Wales court to take oaths, or the person who appointed by the court in the requested state to take oaths. But the China say no, okay? So China say, the witness must sign the written warranty and also reading out. So read aloud of the warranty essentially is taking the oath. So the oath must be administered by the Chinese court. Any witness who refused to sign or read aloud the warranty should not be allowed to give testimony. But in New South Wales law, we actually is the probative effect of unsworn testimony, in the probative legal effect may be degraded by the court. So regarding the perjury and contempt, in New South Wales law, we consider the lex fori should be applied, the same as Chinese law. So actually it's the conflicting of the issues if both jurisdictions consider their law should be applied. And regarding privilege and immunities, New South Wales law is the lex fori issues because it's the procedure law. In China, I put a question mark because there's no provisions regarding privilege and immunities. There is a provision regarding in what kind of circumstance the witness can request not to appear in court or appear in court by video and audio link. So one situation is the natural disaster, and the COVID-19 certainly satisfy the requirement. Okay, so I just quickly summarize, and I'm looking forward to your questions. Okay, Vivienne. So, sure, let me.
Well, good evening, and thank you to you all for attending. I apologise for my sinister black background. It's designed to prevent light shining off the screen. What I'm going to talk about tonight is something a bit different, because what I was interested in was the question of potential private international law issues relating to COVID-19. I've seen a number of summaries referring to breach of contract and termination of contract, referring to the doctrine of frustration under common law and force majeure under civil law, particularly Chinese law. But that's as far as the discussion goes. It doesn't then pursue the next question, which is what are the private international law implications when you have or try to apply the doctrine of frustration or force majeure to a transnational contract. Now, of course, just to revise in relation to questions of contract and private international law, in theory at least, the proper law of the contract determines the questions of breach, discharge and termination, but this may be subject to contract terms and any restrictions on the ability of the parties to choose proper law and relevant mandatory laws. Now, what I'm going to focus on is the question of foreign government regulation and its impact on transnational contracts in a private international law context. And the reason for this is that when we look at COVID-19, I think that a lot of the arguments which are going to be made in relation to termination or suspension of contractual obligations are in fact due to government action. So we have the lockdown of Wuhan, we have the closure of factories in China, we have restrictions on travel in China, Australia and other places, export control certifications and so on, all of which have involved a large degree of government intervention. So what I'm going to consider is the question of termination and discharge due to COVID-19 events and what this means in terms of foreign law and the use of foreign laws. So, for example, we have frustration as a common law doctrine due to a Chinese law event, force majeure under Chinese law due to either a Chinese law or perhaps an Australian law event, illegality, mandatory rules of the forum, and of course, evidence and proof. I suspect I'm not going to get through all of this, but I'll see how I go. Now, the thing about frustration is, of course, it's extremely difficult to prove. It occurs whenever the law recognises that without default of either party, a contractual obligation has become incapable of being performed because the circumstances in which performance is called for would render it a thing radically different from that which was undertaken by the contract. That's Lord Radcliffe and Davis Contractors and Ferrum Erm District Council. So frustration can be caused by factual circumstances, or it can be caused, in fact, by intervention of foreign law. And if we do have intervention of foreign law, then we have a whole lot of issues which the relevant court is going to have to consider in relation to foreign law. First, what is it? Which raises the question of proof of foreign law. How does it or should it apply to the current case? What is the legal effect? What is its status? Is it mandatory? And what's the result of a breach of foreign law? And finally, is the law or regulation under foreign law itself illegal or invalid? So a couple of examples of this in terms of foreign law. The first one is PT Eratman Indonesia and PT Thies Contractors Indonesia, which is a Queensland law case. And this was a case in which we had two Indonesian incorporated companies with a contract which was subject to Queensland law. And it required determination of a number of factual and legal issues under Indonesian law due to a change in Indonesian policy to essentially require that Indonesian companies or Indonesian-owned companies were the companies principally engaged in mining and natural resources extraction in Indonesia. And what it involved was a cascade of laws, regulations, directives, and guidance documents issued by various parts of the Indonesian government, all of which, of course, was based on expert evidence given to the court. But the point which I particularly noted in that case was what it came down to in the end was a challenge to the validity of a foreign government guidance document issued by part of the Indonesian government under Indonesian law. And the claim was made by Eratman that essentially the Queensland court should hold that this particular guidance document was invalid as a matter of Indonesian law. Now, Thies replied that the court could not do this, that it wasn't entitled to review this on sovereign state grounds, an active state doctrine. The court, in fact, found that it could review it, but decided not to on the basis that Eratman could challenge validity in Indonesia itself. A similar example, or an equally complex example, is Canary Wharf and European Medicines Agency, in which an EU agency challenged the validity essentially of its lease, 25-year lease in London, on the basis that Brexit would be an event frustrating lease. And this involved the court considering a number of interesting issues. First, whether an issue of private international law arose at all, since the UK was still part of the EU, whether a referral to the EU Court of Justice was required. There was a public international law issue, an argument of supervening lack of capacity on the basis that although the EU entity had capacity to sign the lease in 2014, it had lost that capacity or would lose it by virtue of Brexit. And of course, the frustration arguments itself. Now, when we look at this in the context of China, we are easily able to envisage that these same problems and issues would arise. China is also a jurisdiction where we have formal laws, we have administrative regulations, and we have a whole plethora of court interpretations, ministry directives, provincial governments, city governments, local officials, local departments, and so on, all issuing various kinds of regulatory documents. So certainly trying to prove frustration on the basis of Chinese law could itself be quite a difficult task. And let's turn a bit to the converse position, which is China and force majeure. Now, as defined in the contract law, a force majeure event is something which is unforeseeable, unavoidable, and impossible to overcome. And I've got a little note here saying that we could also look at the Convention on Contracts for the International Sale of Goods, but we won't do that for the moment. Now, if you can show an event of force majeure under Chinese law, you can be excused from civil liability in relation to non-performance. And in principle, at least, it applies when the contract is governed by Chinese law. So if we look at the issues in terms of private international law, even if we're looking at a force of majeure as a result of the action of Chinese law, we'd have to distinguish between the implications of formal laws and regulations, as opposed to government directives and advice and opinions, and the individual actions of officials. As Sophia Tang pointed out in a blog for conflictoflaws.net, you would have to distinguish, for example, between a government regulation which formally required you to close down your factory and an individual decision by the owner of the factory to close down the factory due to COVID-19. Then again, you could also have a semi-official or quasi-official recommendation by the local police force that you did so. So certainly you could have some very difficult issues there in terms of proof of foreign law if you had to contest in court whether your force majeure had been caused by the intervention of Chinese law. The next category in terms of contracts which potentially presents issues is the question of illegality under foreign law. And this is something which relates, of course, to the question of enforcement. The rule of domestic law in Australia, the UK, and common law states that the forum court may decline to enforce a contract in particular circumstances. So if it's unlawful under the law of the place of performance, for example, in China, and it came to be enforced in Australia, then an argument could be made that it should not be enforced. Similarly, if it's unlawful under its proper law, obviously it would not be enforced. And then again, we have issues of the mandatory law or public policy of the forum. Now, I should say here that illegality under foreign law is not relevant if it's unlawful under the law of the place of contracting, the place of incorporation, in relation to continuing obligations, as was argued in Canary Wharf, and it's not relevant if the act is illegal in the place of domicile, as was argued by the Bank of China in Spieltoff's Befragtungskantor BV and the Bank of China. In that case, the Bank of China had entered into an English law guarantee submitted to the jurisdiction of the English courts, but a stop order was issued in China itself, ordering the Bank of China not to pay under the guarantee. The English court was not sympathetic to this claim and said that it was not relevant to the enforceability of that particular act. Now, how does this work in terms of, say, a COVID-19 event? The problem with it is that it's a very mixed and very legalistic sort of doctrine. So the example I've pulled out here is a case called Ryder Industries and Chan Shui Wu, which is a 2015 decision of the Hong Kong Court of Final Appeal. And in that case, there was a Hong Kong law contract requiring performance in China. Both companies were incorporated in Hong Kong and had subsidiaries in China, and these subsidiaries, in a very broad-minded approach to Chinese rules, committed quite a number of breaches of Chinese rules relating to contract manufacturing, bonded goods, sale of goods in China, and so on. And when Ryder Industries brought a case in Hong Kong to enforce a guarantee supporting the contract, the argument was that essentially the contract constituted an evasion of PRC law, and the contract was tainted by illegality because there were breaches of customs rules, outsourcing in breach of the measures of customs for supervision of goods for processing trade, and so on. And the court said that not every breach of foreign law would mean that it was contrary to public policy to enforce a contract. They looked at how the transgressions would be regarded in China in order to assess whether the breach should result in enforcement. And they decided essentially that they weren't very serious. They were not iniquitous. They wouldn't have resulted in they didn't result in actual criminal or enforcement proceedings in China. In fact, they were mere administrative contraventions, so there was no reason not to enforce the guarantee. Of course, what we're left asking ourselves about that are some acts more illegal than other acts? And what would the place of performance in China really think about it if a case had been brought in China in respect of the same guarantee and enforcement of the same contract? Now, the final category of government rules which really present problems in terms of these contractual issues is the question of mandatory laws. And of course, a mandatory law is where the forum has an overriding choice of law, a law which overrides the party's choice of law, for example, specifically or implicitly, or otherwise you have a statute of general application which overrides the choice which the parties have made. Of course, if the mandatory law is the law of the proper law of the contract, then the forum must apply that. So if we have a China-Australia contract, for example, if the proper law is Chinese, a New South Wales court should apply any mandatory law of China which applies in relation to that particular contract. So if it's China-Australia contract and the Chinese law, say, exempted producers from liability for delays by reason of COVID-19, then the Australian law should apply that. The Australian court should apply that. The question, of course, is always going to be, is the law or regulation actually mandatory under the proper law? If it's a subsidiary regulation, for example, or a directive, or a policy, is this something which is mandatory under Chinese law? But you also have the related issue, even if the proper law of the contract is New South Wales law, of whether there's an effect on the performance of the contract in China by virtue of Chinese mandatory law, which may prevent the supplier, for example, from sending stuff outside China because medical supplies are required in China, for example. And certainly there would be an effect in China in relation to enforcement of the contract if the Chinese court took the view that mandatory law overrid the actual decision of the parties. So mandatory laws have quite a significant potential impact. The other problem in China in terms of mandatory law, as it is in Australia, I have to say, is the question of what laws are in fact mandatory. So we know in relation to choice of law that Chinese laws of labour protection, food or public health, environmental matters, financial safety, anti-monopoly and anti-dumping should be regarded as mandatory in relation to choice of law. In relation to general laws, though, it's not clear which ones would in fact apply if they came up before a Chinese test. And in fact, the rules are really rather confusing. It's not clear, for example, in most cases, whether mandatory laws are only those laws passed by the National People's Congress or the National People's Standing Committee, or indeed the State Council itself, or whether it extends to rules which go further down, ministry rules, for example, or local rules, or local regulations of that kind. So there's a good deal of confusion in relation to that. Also, it means you have to read them fairly carefully. because, for example, in relation to the regulations and rules issued in relation to COVID-19, the announcement on the certification of the export of medical supplies is clearly not a mandatory rule. So I think I've probably come to the end of my time there. I'll just have a little note there here saying, obviously, proof of foreign law is a problem. Proof of events in China and issues of this kind are general private international law issues. And just as a final slide, there are the long-term private international laws relating to China, which would equally apply to contracts, which are the difficulty in enforcing foreign judgments in China generally. The problem that China does not have any effective rules relating to lis alibi pendens or forum non-conveniens, which means that quite often you do have parallel proceedings in Chinese courts and Australian courts potentially at the same time. And of course, the refusal of Chinese courts under the civil procedure law to recognise the choice by the parties of the courts of a third party neutral state to hear a dispute between them. So if our Australian and Chinese parties notionally chose the law of England, then the Chinese courts would say, well, we don't recognise that choice and we'll hear the case ourselves. So I'll stop here and open up for questions.
All right, thank you so much, Vivienne and Jeanne. I feel like in listening to your presentations, we've really just got sort of the tip of the iceberg in the plethora of issues, and it's going to be something obviously that we will have to watch over time as all of these disputes unfold. We are getting close to the end of time, but there was one question that Brooke Marshall had posted for Jeanne. Jeanne, did you have a few thoughts on that before we wrap up?
Yeah.
So the question for everyone, just in case, the Secretary General of the Hague Conference has remarked in his forward to the Guide to Good Practice on the use of video link under the Evidence Convention that the drafters of the convention had the foresight to adopt an approach that is completely technology neutral. So to what extent is that true in practice, given all the references to internal law? Jeanne, do you have a brief thought on that for us, please?
Yeah, so I think the answer is yes or no. So why it is yes? Because as just now I said, Article 7, Article 8, the meaning of present. So Hague Conference of International Law, they interpreted present as including present by video and audio link. So in this sense, I think a strong argument can be made. Hague Convention, a very old convention, actually contemplates the future, the development of technology. But why it is no, I think a very important reason is even you look at that good practice, it consider the request of audio video link as a special request, arrangement subject to Article 9, paragraph 2. So what's the implication of that? Because if it is a special arrangement, it means that the requested member state can reject this request according to its internal law or based on the practical impossibility. But if it is not a special arrangement, which won't be subject to Article 9, paragraph 2, it means that the member state can only reject that request based on national sovereignty or national interest. So if you compare the rejections, because if you know the good practice consider the video and audio link is a special arrangement, which actually expose it to the internal law rejections. But if we consider it is not a special arrangement, it has already been contemplated by the convention, which means the possibility of rejection by the request state is much lower. Okay, so this is my view, yes.
Great, thank you. And there's just a short question about investor-state dispute settlement and where that falls. I suspect that's a whole separate topic itself in terms of force majeure and perhaps, Vivienne, if you want to answer, but I will note that we are planning another seminar coming up probably mid-July that will look more at international commercial arbitration and probably bring that up. But did you have any preliminary thoughts? Vivienne,
I don't think I can really answer that in 30 seconds. Though,
No.
I would say that, you know, you've got the public health exception in most treaties relating to ISDS. I was wondering when I saw the question whether if you had a whole lot of economic measures which are put in place in order to try and rebuild the economy after the pandemic, whether those measures would necessarily come within your public health exception. But apart from that, I think that we might have to leave it to the whole program to actually ponder ISDS.
Yes, and similarly to some of these issues that are going to emerge in our courts, I think there is going to be a lot happening in the investor-state dispute settlement space as well. So we will be talking about that one in the future. But given the time, I'm afraid I will have to wrap this up here. But really very warm thanks to both Jeanne and Vivienne for their time and sharing their thoughts on what are very complex matters, and that I think we're really, as I said, just start of seeing. I also just wanted to thank Tom Chapman and Chris Katselis from UNSW for helping with the logistics on this, and Kaylin Chen and Jennifer Tridgell from the ILA in helping support this, and also to let everyone know about our next seminar, which is scheduled for Thursday, June 4th at 5 p.m, which is going to be on COVID-19 and international refugee law. We're very happy to welcome the Assistant Secretary General, Gillian Triggs, who is the Assistant High Commissioner for Protection, and also Professor Jane McAdam from the Kaldor Centre for International Refugee Law, to speak with us at that seminar. And on Thursday, June 25th, it will be COVID-19 and human rights law. We'll be joined by Professor Louise Chappell from the Australian Human Rights Institute and Elaine Pearson from Human Rights Watch. And as I mentioned, also in July, looking once again at some of the commercial ramifications. So we will be posting notices about that. But now, thank you all so much for joining us this evening. We will have a video that will get posted in the next week or so via our usual channels, but appreciate your time and participation tonight. Thank you all.
Thank you.